Hello, students. This is the video lecture for Chapter 2, JMS 494. It's all about the First Amendment. First up, I'm going to read. I know y'all can read. You've made it this far in college, but nonetheless, I'm going to read it anyway. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press. And many people forget this last part, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. Okay, these amendments, the first 10 amendments, also known as the Bill of Rights, added to the U.S. Constitution 1791. If my memory of high school history class is correct, the reason was when people from the early colonies, we were at the states, right, were trying to decide if they wanted to approve the U.S. Constitution. Some people said, hey, there's not enough of these provisions for protection. We don't want a big evil government. We had that before. We need some provisions there. So the deal was, hey, just vote for this Constitution now, and then we'll add the some amendments later, which is what they did. Okay, anyway. Theoretical foundations. This is where the textbook begins, 1791. I already mentioned that. I did want to stress, though, that the First Amendment is a restriction on state action, and many people don't know that, especially people who didn't go to college or people who didn't take a class like JMS 494. I repeat, the First Amendment is a restriction on the government. It is not a restriction on private actors. Okay. If I wanted to wear a very offensive t shirt on JetBlue, said F JetBlue or whatever, I'll go Delta Airlines, F Delta, Delta sucks, whatever. If I want to put that on my shirt, they could say, sir, you can't wear that. You can't get on the plane. I can't go screaming and cry First Amendment violation because that airline is a private entity. And presumably, when I bought the ticket, I clicked something that said I agree to their terms of service. Same thing, we're going to a theme park. If I went to a theme park and I wanted to have a t shirt where Mickey Mouse was doing something really vulgar, say to Goofy or to Minnie Mouse, I think Disneyland would be in their right place to say, sir, you can't wear that. It's going to offend people in the park. This is not we're family business, blah, blah, blah. Even though that image on my shirt technically may not meet the definition of obscenity or indecency, they could say, we don't want you to wear that. Again, I couldn't go screaming and crying First Amendment rights because the government couldn't come in and punish me for wearing this. Now we've got this example of this, vulgar Mickey Mouse t-shirt. The government can't penalize me for that, again, unless it meets sort of a legal definition of obscenity or indecency. But Disney could tell me not to come in their park, and then the airline could say, we don't want you coming on our airline like that. And this point here, should private actors have so much power? It's a big question, and it is discussed late in the textbook about what we mean by a public forum on private property. If I sign up for a social media platform, again, I'm clicking on some type of terms of service. And if Twitter or Facebook or Instagram, whatever, says, we think you have violated our terms and you can no longer use our service, well, I can't really, I don't have a First Amendment argument there. I do not have a First Amendment argument there. The government can't punish me for saying things, but Twitter or Facebook or some social media platform could say, we don't want you around here. Whether that's the best situation or not, that's a matter of debate. I'm just stating you the way it is, that the First Amendment is a limitation on the government. And then the textbook also talks about this marketplace of ideas concept, the idea being that more speech is better than less speech, and that if we have negative speech in the world, we can drown it out with positive speech, and that eventually the correct, truthful, the correct idea will be victorious. That's the idea. This is an example going back a few years, but I don't think it's too old. Hopefully, y'all are familiar with this. Colin Kaepernick. He's in the center of this photograph right here. Football player, quarterback, and got some fame, notoriety, whatever you want to call it, for kneeling during the national anthem before professional football games, saying that, the flag and what it symbolizes. I think this is what he said or meant, that, the flag and what it symbolizes, freedom and liberty, justice for all, doesn't apply to everybody. And that people of color in particular are treated unfairly, often at the hands of police, often killed by police. And I'm protesting this by just bringing attention to this matter by kneeling during the national anthem. Well, this upset a lot of people, you know, that they thought it was disrespectful, bringing politics into football. And, you know, I don't follow sports that closely, but it does seem as if the owners of the NFL didn't like what Colin Kaepernick was doing and, you know, sort of engineered it so that he was no longer in the league and treated him unfairly. I don't think he has a First Amendment claim because the NFL, again, back to that point I made, the NFL, these are private entities. They're very wildly successful, have, you know, a ridiculous amount of money, a great deal of social influence, but it's not a government entity. So if the NFL said, we're going to kick you out because we didn't like the way you were kneeling, they could have done that. Should they have done that? That's a different question. But like, he cannot claim First Amendment. He could only claim a First Amendment uh, argument if he was somehow arrested for that, and he was never arrested for doing that. Going back, this is just a little historical detour about the intersection of sports and politics, a very famous event from 1968 Olympics. These two athletes, African Americans, for the American team. I don't know what event they was, but it's something to do with track and field. They had agreed to do gesture, this gesture, and one of the individuals, his wife, had a pair of gloves, black pair of gloves. That's why one guy has the glove on his right hand, the other guy has it on his left hand, and it looks like the classic Black Power salute. That's what it looks like. They later said it wasn't a Black Power salute. It was just a statement of solidarity for human rights with all the people who are oppressed throughout the world, which is a good gesture. You can't object to that gesture, right? You know, you want to support people who are being oppressed. They were punished. They were punished by the U.S. Olympic Committee after doing this on the podium. This is probably the most famous intersection of sports and politics, you know, except maybe Muhammad Ali refusing the draft for the Vietnam War. Anyway, now this is a really ambiguous and more tricky case than the Colin Kaepernick NFL, because, you know, the U.S. Olympic Committee, or whatever it's called, that is kind of a quasi branch of the government, and that is sort of acting on behalf of the government. So if the U.S. Olympic Committee censors these individuals, that could lead to some type of First Amendment case. I don't think it did. But I'm just trying to illustrate that, you know, if some private business says, "Sir, you cannot wear this T-shirt," or "Ma'am," or whoever person, you can't wear this T-shirt. That private business can do that. They are allowed to do that. Now, there is a discussion in the textbook about technology and the First Amendment. And it's a good discussion. It's relevant because when the forefathers, you know, who write the U.S. Constitution, when they write press, that was the only means of mass media at the time. You actually literally had to print something to get it distributed. Well, you know, if you wanted to take an original, like a purely original intent, a purely, you know, original interpretation of the words of the Constitution, it wouldn't apply to any form of media except print, but that doesn't make any sense. So people have commonly understood it to mean freedom of the press means any form of mass communication where one or a small group of people are communicating with a vast group of people, including radio, including TV. Okay. Now, radio and TV have their own set of limitations. We talk about that later in the semester because of something called spectrum scarcity. You don't have to know it now, but you have to know it later. Because of spectrum scarcity, the FCC can issue guidelines about content and material on the airwaves because of spectrum scarcity. Newspapers enjoy, and magazines, far more freedom, and on the internet it's the Wild West. You pretty much do whatever you want with certain limitations. But now we have this question of, like, you know, and the courts had to decide, was liking something on Facebook an act of speech, just clicking like? And I'm reading from some notes here. On the most basic level, this is what the judge said. On the most basic level, clicking on the like button literally publishes a statement that a user likes something which is itself a substantive statement. That a user may use a single mouse click to produce the message that he likes the page instead of typing out the same message is of no constitutional significance. So, yes, liking something on Facebook is an act of speech and would therefore garner some First Amendment protection. Now, the textbook, it's impossible to keep up to date because this stuff changes all the time, but this is from September 2022, showing the different, based on sort of market capitalization of different media companies. And I think the reason that it's brought up here is that it's hard to define what is a media company. Apple, Google, Amazon, are also tech companies as well. But you have a handful of companies that own so many things. Warner Brothers Discovery is probably going to merge with someone like Comcast. Disney might buy something like Netflix. We seem to get the illusion of a multiplicity of sources, but in reality, it's a concentrated control over all these various media outlets. Does this have First Amendment implications when you have 4 or 5 or a handful of companies dominating most of the messages that we consume electronically through a screen, through your phone, TV, whatever it is, through the car dashboard? If a handful of companies are controlling that, they could exert a massive influence on public opinion and limit certain points of view. That's not the government doing it, but I think it is something the government can be aware of, and that the government, has a right to look at these type of media acquisitions and media mergers and things. There are different categories of speech. Political speech is the highest form of speech, deserving of the most protection. Commercial speech, meaning something that's trying to sell you a product or get you to engage in a goods or service, that has less, doesn't have zero, but it has less. And then there are other types of speech, which we'll talk about at another time, which have zero. Now, the textbook talks about a couple of cases which I think are interesting. There was a federal law called the Stolen Valor Act, which made it illegal to the point was to make it illegal to lie about military service and try and profit from that. The courts and judges actually said it's okay to lie about having U.S. military honors. Yeah, it's very odd. It's very odd. It's on page 64. They could punish you for wearing medals that you didn't earn. The military could punish you for wearing medals you didn't earn, but actually saying you did something in combat which you did not is okay. And then this last one I think is really intriguing. This one gets to that marketplace of ideas concept, that idea that more speech is better than less speech. That there was an Ohio law prohibiting false statements during a political campaign. This was found to be unconstitutional. The idea was that let's let out more speech to drown out that negative speech, and let's not go in and penalize this kind of speech. Again, that is from the textbook. I find that to be an odd ruling, but there are different ways that courts interpret and make decisions based on the First Amendment. Prior restraint is no good. Okay, you should know that. Prior restraint is when the government is trying to stop some type of speech or communicative act before it even happens, and come in early. This is really, really frowned upon. It is permissible in certain limited instances, but the governments really do not like prior restraint, generally considered to be a bad word. The Pentagon Papers, if you're not familiar with that, you should be. In the early 1970s, there were some secret documents about the ongoing war in Vietnam that were leaked to the New York Times and the Washington Post. The information conveyed in there was very, very embarrassing for Nixon, who was president at the time. But in fact, it was embarrassing for a number of previous presidents. It revealed that the US government had been lying to the public for quite some time, a decade, maybe even more, about what was going on in Southeast Asia and how well or how poorly U.S. forces were doing. This was, this was a massive, massive campaign of deception and, let's say, propaganda. Let's use that word, to the American people to get them to support the Vietnam War, which many people didn't agree with. Many people did not think that we shouldn't have been involved in that foreign conflict. Very embarrassing. The court said that the prior restraint was not acceptable in this point, and ultimately the Times was able to print. It was the New York Times and the Washington Post, but they were able to print the Pentagon Papers. Very, very famous case, landmark case, showing how much courts disapprove of prior restraint. When can prior restraint be justified? There are, the wording, the literal wording of the First Amendment is Congress shall make no law. Congress shall make no law, but we have many, many, many laws. So there's many, many exceptions to it. If there's clear and convincing evidence that speech is going to cause some great and certain harm, there are topics like national security. There are all kind of provisions about courts. We have another lecture about courts. There's use of copyrighted material. So if literally we had no law, then there would be no laws about what you could say or communicate or print, but we do. You can't use other people's copyrighted material. Child porn is the most forbidden thing, and it should be. That we have laws against that. But national security and concerns about national security are often at the center of government attempts to cut down, censor, or limit the flow of information. How does the Supreme Court review laws that relate to the First Amendment? Here, I'm going to move myself right here. Okay. If it's a content-based law, meaning that they are trying, the government, in this case, the government, are trying to object to entire genres of speech or entire topics, that's generally considered unconstitutional. And any law would have to undergo strict scrutiny. That's a legal term. It is pretty sure it's talked about in the textbook. Let me make sure. Yeah, pretty sure. Yeah, page 70, strict scrutiny. And contrasted with intermediate scrutiny. Okay. Content neutral laws are laws that ostensibly have nothing to do with the nature of the message itself. Sometimes these are called time, place, manner laws. Content neutral laws are often called time, place, manner laws because there is a restriction on the time, place, or some method of communication. These are often found to be constitutional, and they only have to undergo something called intermediate scrutiny. In the case of this burning of draft cards, there used to be draft cards during the Vietnam War. A lot of cases relate to the Vietnam War. Yeah, U.S. O'Brien, United States versus O'Brien. Individual claims that burning his draft card was a symbolic act should be covered by the First Amendment. The court said that there was a interest. What did they say? Yeah, there was an interest. The government has an interest in limiting this activity, and it's only placing a very small burden on symbolic expression because the individual is free to express his viewpoint in other ways. So yeah, there was an important or substantial government interest. That's the phrase I was looking for, an important or substantial government interest. Anyway, take a look at that. You should be familiar with the O'Brien test, or at least what the O'Brien test relates to. It relates to content neutral laws. Now we have, I'm not going to go over these point by point because I think you can read that. It's in the textbook. But there are different kinds of speech and different protections and different boundaries for different kinds of speech. A political speech is at the top, right? The government wants to protect political speech. And then there are different rules about government speech. Now, this concept of compelled speech is on my mind. This topic of compelled speech is on my mind. You are allowed to say whatever you want according to the government, but by that same token, the government cannot force you to say something. We call that compelled speech. There was an argument against the fairness doctrine, again, something we will be talking about later in the semester. Fairness doctrine said that radio and TV stations had to air both sides of a controversial issue. People argued, and this was a generally successful argument, that if I'm coming out and I'm saying, like war in Vietnam is bad, I say the war in Vietnam is bad. If I have to give the other point of view that the war in Vietnam is good, it's justified, it's totally worthwhile. If I, as a newscaster or TV station, am being compelled to put that point of view, you are compelling me to say something to which I don't agree with, so the government should not be compelling speech. And the reason it's on my mind is this Supreme Court case. I'm recording this, being fully transparent here, July 2023, Supreme Court case about a person who was making websites for marriages, like a marriage website. Supreme Court said this individual was okay to deny service to same-sex couples. And it gets to this, and it's decided on a First Amendment basis related to this compelled speech argument. If I, as a web designer, do not want to make a website for a same-sex couple, if I'm now forced to because of anti-discrimination laws, you are therefore forcing me to engage in expressive conduct with I do not agree with. That was the argument that was successful. Can this argument be extended to other businesses if they are clearly engaged in expressive conduct, like writing a poem, writing a song, writing something like that? Web design, I can think be expressive conduct. Food, now this is going to be a big area. At the time of this writing, it's going to be a big area. When someone said my expressive conduct is the food that I put on the plate, you cannot force me to give food to people I don't agree with. I just think it's going to be a can of worms. I'm not going to say one way or the other about it, but I think it's going to be a can of worms if you say you can withhold service from someone on the basis of the First Amendment. I think it's going to be a interesting future. And then there are rules. Again, see the textbook on this. There are certain rules about election speech. There are certain rules about anonymous speech. And I think I'm going to leave it. All right, that's it for lecture number 2. Moving on is another lecture about some distinctions within the First Amendment, specifically how we deal with words and phrases and viewpoints that we don't agree with and that we find objectionable or disruptive.